In this video, we are going to look at another essential of a valid contract, which is genuine consent. And we are also going to look at vitiating factors in this case. So the meaning of genuine consent is someone agreeing to the contract when they know what they are agreeing to without being forced. So a contract must be entered into voluntarily with genuine meeting of minds. However, certain factors can invalidate an agreement, making it voidable. So these are known as the vitiating factors, the factors that can invalidate an agreement, that make it voidable. And these include, we have 4 of them. We have misrepresentation, we have mistake, we have duress, and we have undue influence. Genuine consent is fundamental to a valid contract as it ensures that both parties agree to the terms. So if consent is obtained through deceit, pressure, or misinformation, then the contract becomes voidable. Yes, so this is where vitiating factors come in. So these factors undermine the genuineness of consent, making the contract potentially voidable by the affected party. So we are going to look at each of the vitiating factor in details. So we have the first one, which is misrepresentation. So misrepresentation is an untrue statement of fact that induces a party to enter into a contract, but it is not part of the contract itself. So misrepresentation occurs when one party makes a false statement that influences the other party to enter into a contract. This misrepresentation, most of the times, it's not part of the contract itself, but it plays a role in persuading the other party to agree to the contract. Let's look at the types of misrepresentation. The first one is the fraudulent misrepresentation. This one occurs when one party knowingly makes a false statement or has no belief in its truth. So in this case, a party deliberately makes a false statement with the intention of deceiving the other party. For example, if a seller knowingly tells the buyer that the car is brand new when it is actually not brand new, then it is fraudulent misrepresentation. So the buyer can rescind the contract and then seek for damages. Then the second type is negligent misrepresentation. So this happens when a false statement is made without reasonable grounds for believing it to be true, often by a party with a duty of care. So negligent misrepresentation occurs when one party makes a false statement without taking reasonable care to verify the truth of that statement. So even if they do not intend to deceive the other party, like they just do not know, they just mentioned something out of the blue. So in this case, the person making the statement is careless in ensuring its accuracy, which leads to the other party relying on that false information when entering in the contract. Yeah, so unlike fraudulent misrepresentation, in negligent misrepresentation, there is no intention to deceive, but the person just failed to act responsibly in confirming whether what he or she is saying is true. So, for example, if a real estate agent tells you that property has no structural issues, but the agent hasn't checked or verified information, then this is negligent misrepresentation. The buyer might rely on this statement and decide to buy the property and later discover the truth that it has issues. So the buyer has the right to rescind the contract and seek for damages. So for fraudulent, it is done intentionally, then negligent, it is not intentional. Then we have innocent misrepresentation. This one occurs when one person without reasonable belief in the truth of a statement unknowingly makes a false statement. So for this case, a false statement is made without knowledge that it is false. So for example, a car dealer genuinely believes that the car being sold has low mileage, but later it is found that it was tampered with. So this was innocent misrepresentation, and the contract could be voidable. So even the car dealer didn't know. So the statement is made without knowing that it is a false statement. Yes, so those are the three types of misrepresentation: the fraudulent, the negligent, then the innocent one. So a misrepresentation makes the contract voidable, and the affected party may choose to affirm or rescind the contract upon discovery of the misrepresentation. The second vitiating factor we have is a mistake. So a mistake is an erroneous belief about a fact that affects the contract. So mistake falls into three main categories. We have the common mistake, we have the mutual mistake, and then we have the unilateral mistake. So for the common mistake, both parties make the mistake about a fundamental fact. So if the mistaken belief relates to the existence of a subject matter, then the contract is void. This was seen in this case whereby there was a contract to sell corn, and the corn mentioned in the contract had perished before the contract was formed. So this was a common mistake. So both parties were mistaken about a fundamental fact, and that fundamental fact was about the subject matter, which was corn. So corn had perished even before the contract. Then we have the mutual mistake. So mutual mistake here, each party misunderstands the other, leading to no real agreement. So both parties misunderstand each other's intentions or terms, leading to no real agreement. And this was seen in this case whereby the contract was void because each party believed that they were referring to a different ship. So since there was no understanding between the two, or each party misunderstood the other, meaning there was no contract between the two. Then we have the unilateral mistake. Here one party is mistaken and the other party is presumed to be aware of the mistake. And this is common in fraudulent contracts where one party misrepresents their identity. So for unilateral mistake, one party is mistaken and the other is aware of the mistake. For example, if someone mistakenly offers to sell an item of $1,000 when it is worth much more, and then the buyer knows about the error but still accepts, then the contract may be voidable due to the unilateral mistake. So the seller made a mistake on the price of the item, but then the buyer knows the real price of that item, but they decide to keep quiet. Yeah, so this contract can be voidable due to the unilateral mistake. Then another vitiating factor we have is the duress and then undue influence. So for duress involves making a threat to force someone into a contract. So it involves an illegal threat used to force someone into a contract, making it voidable. So it usually involves threats of violence or unlawful confinement. It was also seen in the case of Burton versus Armstrong. This contract was voided because one party was threatened with death if they refused to comply. Another vitiating factor we have is undue influence. Undue influence occurs when one party uses their position of power or trust to unfairly influence the other party's decision to enter into a contract. So a contract is affected by undue influence when one party uses their position of power to unfairly influence the other. So it is presumed in relationships such as the parent-child relationship, like the parent can influence the child to do something they do not want to do just because they are their parent. Then the doctor-patient relationship, the trustee/beneficiary relationship. So undue influence makes the contract voidable, like the other party can withdraw from it because it prevents genuine consent. So genuine consent is crucial for a valid contract. Misrepresentation, mistake, duress, and undue influence can undermine consent, rendering the contract void or voidable. So understanding these vitiating factors helps in ensuring fair contractual agreements.